sponsored by Colera. These sessions have been approved for CLE credit. So I see that people are now registering their name and turning registration numbers in the chat. We'll be checking throughout just to make sure we maintain Supreme Court status with our CLEs. I want to thank Chris, our Vice President, for all the work she's done behind the scenes and getting these sessions approved for CLE, as well as the certificates that she distributes after the fact. Thank you so much, Chris. I greatly appreciate everything you do for Colera. Now, our speaker today is Arbitrator Robert Brookins. Originally scheduled was Charles Colera, but Arbitrator Colera had some family issues that he had to deal with. And Dr. Brookins graciously stepped in to fill his spot. I am greatly appreciated that he answered my call. Met Dr. Brookins, I think it was on a panel with OCB in one of their trainings. We had a diverse panel that year. It was you, myself, and Dwight Washington, who's now deceased. I don't know if you recall that.
Yes, I do. I do recall that.
And I've kept in touch over the years, so I'm just grateful that you hate to exploit all my friendships, but thank you for filling in today. Arbitrator Brookins is a professor of law at Indiana University, Robert H. McKinney School of Law, is a longtime member of the National Academy of Arbitrators. Arbitrator Brookins serves on various rosters of neutrals, including the American Arbitration Association and Federal Mediation and Conciliation Service. He is currently a permanent panel of the OCSEA and AFSCME Local 11 in the state of Ohio and the Greater Cleveland Transit Authority. And Dr. Brookins, we have a lot of OCSEA participation in this academy, so you'll be looking at some familiar faces.
Yeah, I see some.
Arbitrator Brookins has decided many issues ranging from A, absences, to W, work rules. I don't think there's any Z that I know of, and has worked in various industries from airlines to warehousing. His academic publications are extensive, but they include A Rose by Any Other Name, The Gender-Based Basis of Same-Sex Sexual Harassment. Policy is the Lodestar When Two Wrongs Collide, After Acquired Evidence in Employer Liability. The other one I think I picked up was Hicks, Lies, and Ideology. The Wages of Sin is Now Exculpation, Mixed Motives, Title VII, and Removing Sexism, the Rhetoric and the Reality. And I think he has a work in progress, Tea Leaves and Crystal Balls, Employer Liability for Sexual Orientation Discrimination under Title VII. Arbitrator Brookins received his Bachelor of Science in 1974 from the University of Florida, his Juris Doctorate in 1978 from Cornell University. He has his PhD in 1990 from Cornell as well. So thank you again for joining. And at this time, I will turn the presentation over to Dr. Brookins.
Good morning, and thanks for having me. So I'm going to talk this morning about arbitration, off-duty misconduct, the element of intent in an employer's charges, and the factors involved in remedial decisions. Remedial decision, of course, being the remedy that the employer has, those types of standards that the employer has to meet when he imposes some type of discipline. The arbitrator looks at that discipline and decides whether that discipline is proper, and that type of assessment is usually looked at as the remedy, the proper remedy. So I'm going to start here with off-duty misconduct. Now, I'll go to off-duty misconduct, and that's what I'm going to discuss, but a brief contrast between off-duty misconduct and on-duty. When an employee engages in misconduct on the job, and on the job can be on the premises, or it can be in the employer's vehicle, or if the employee's job is really not on the premises, off the premises, that's still considered on duty or on premises. So off duty is when the employee is away from work. He is not working. He is not engaged in his usual chores or his usual tasks or operations. He's basically, I will call it his free time. And I put free in quotes because the way things are today, you're never free in any 100% sense. You may not be on the premises, you may not be working or on the clock, but your conduct can get you in trouble. And that's what I want to talk about here today now. And employers have legitimate interest. And their legitimate interest can basically be summed up in terms of their operational interests. That is, they have a right to run their business, and they have a right to run that business without undue interference by employees, either on duty or off duty, operational. And you can break that operational interest down basically into two main categories: productivity and workmanship. If an employee is producing a product or a service, those two factors are going to be the main components of his operational interest. Now, he has a right to protect that interest. Now, the employees have rights also, and their major rights include basically privacy for the purposes of this particular presentation, privacy and free speech. Now, you also have general rights as an employee in terms of just your conduct off duty. Now, the way things are going in our society today, an employee's right to privacy off duty is shrinking. It's basically shrinking as I sit here and talk to you today. Our privacy, our sense of privacy, our rights to privacy are shrinking vis-a-vis the employer. They're shrinking other ways too, beyond the scope of this discussion, but vis-a-vis the employer. I'll give you just some very general notions to support that particular observation. At my university here, Indiana University, and this is how bad it can get. This is one of them that sets the stage. The scope of our rights off duty depend upon the scope of and nature of the employer's interests. Right? Now, we at Indiana University, we have Indiana University Health. We call it IU Health. Right? It's a major medical campus, major. And the employees, the caregivers, the doctors, the nurses there were told that IU Health had created a new work rule. And that work rule stated that employees there who are working with, are going to be in the area of patients who have high sensitivities to smoke because they're maybe suffering from some lung ailments or whatever, but they're very sensitive to smoke. So the rule is that employees who are caring for those patients or who in the vicinity of those patients cannot report to work with the particulates of cigarette smoke on their garments. And that meant that when you come to work, you cannot have been exposed to any environment with cigarette smoke. You don't have to smoke, but if you're in an environment with cigarette smoke, those particulates cling to your garment. So when you come to work, You have to be smoke free in that sense. If you take lunch, you cannot go where there is cigarette smoke. Now, if you happen to be a smoker and you smoke at home, you got a problem, because that cigarette smoke is going to be in that house. Unless you got extremely good ventilation in that area, you're going to have cigarette smoke. And they're going to test you when you come to work. Now, freeze that a minute. You certainly can't smoke in the hospital, but now they're saying if you fall into that group of employees, you probably can't smoke at home unless you have a smoking room. And that's your own time. I just use that as an example because you can see how the nature of the employer's operation and his legitimate interest, in this case, caring for these patients, can intrude significantly into your free time. Now, that kind of paints the picture about this off-duty misconduct. So let's look at some other areas now. I mentioned to you privacy and free speech, but you can see that your general conduct, right? Your general conduct can impact the employer's legitimate interests. I give my students this crazy example when I'm discussing this subject in my classes. Let's say we have a major mall here in our city, and it's called Keystone at the Crossing. So but I'll just say the mall. Imagine it's Christmas Eve and we don't have COVID. Christmas Eve, or 2 days before Christmas. Now, and I am in a convertible. If it's cold, I'm still in the convertible. I'm not driving. I'm standing on the passenger seat, standing. And my feet are in, I'm standing up. And someone else is driving and honking the horn to get the attention of the shoppers. And as he drives by, honking the horn, I am mooning. Now, this is on my own time at the mall, right? I'm a full tenured professor. And I'm mooning, and people see me, and I've been teaching here since 1990. So there are going to be people who see me, and they're going to know that I'm probably Professor Brookins. Now, this is a Saturday. When I get back to work Monday, Tuesday, the following week, I get an email or a call from the vice provost saying, Professor Brookins, we would like to meet with you. Do I have a problem? I'm fully tenured. Do I have a problem? Yes. At least a potential problem, if not a major problem. They're going to want to know why I was behaving that way on my own time. Can you see the nature of their interest? It's reputational. And it can translate to operational if people see me doing that and they connect that to the employer. They're going to want to know why that university retains personnel who act like this on their own time. So there is no free time for many employees in terms of you can just do whatever you want to do, right? There's no free time. If you go home and kick your dog or beat up your wife or whatever, your children, and it gets out into the public, your employer will have a legitimate concern about that. So that's off-duty misconduct. It permeates our lives. That job, when we leave the premises of the work, we're by no means free. All right, now, let's go down to the next point I want to talk about is the employer's burden of proof. Employer, if let's say for me, the employer is going to have to, Indiana University would have to prove that I engaged in that misconduct. They can't just allege it. they're going to have to prove it. And in this particular instance, they probably are going to have something that I call direct evidence. That is eyewitness evidence. And they're going to have that video or someone who saw me. Otherwise, if they can't establish the misconduct, I'm good. But they have to establish. Now, the other way to establish misconduct is basically circumstantial evidence. But circumstantial evidence is not necessarily the major type of evidence where off-duty misconduct is concerned, because you are away from work. And it's going to be very difficult for an employer to try to just say, well, we have some indirect evidence that you did this and this. They're going to have either video or something like witnesses' testimony. Now, circumstantial evidence is evidence that requires an inference to prove the allegation. For example, if somebody wanted to prove that I'm sitting here in my office, to prove that, right? And let's say that I have said I wasn't in my office. If they can find a fingerprint, my fingerprint, on some surface in my office, that is circumstantial evidence of my presence in that office. And ladies and gentlemen, that is very, very difficult to rebut. That fingerprint just sits there and looks at you, right? So it's not direct. The reason it's not direct is because the fingerprint doesn't talk or say or whatever that I was in my office, but it's my fingerprint. And therefore, the employer would be entitled to draw a reasonable inference from that fingerprint that at some point I was in that office. That's the nature of circumstantial evidence. So you can see why with off-duty misconduct, circumstantial evidence, because it requires that kind of inference in those steps like that, circumstantial evidence isn't not as useful in off-duty misconduct as it is in would be in on-duty misconduct. So direct evidence, circumstantial evidence, but mostly for off-duty misconduct, someone saw you or they videotaped you or whatever, doing what you were alleged to have been doing. Now, once the employer establishes that you engaged in that conduct, this off-duty misconduct, he's got to prove that that conduct is linked to his legitimate interests, his operational interests, as I described. So he's got to link that. In my silly example with misbehaving like that at the mall, the employer will have to prove that that kind of conduct is likely to be observed by, especially Christmas time, citizens, some of my students, graduates of a law school, whatever, citizens who know who I am. You got to establish that. Professor Brooks has been at this time. People are likely to know him. He's got to show that in this city, people are likely to recognize me as a professor, number one. He's got to show that when they recognize me, they've got to be able to link me to the university. Now, when they link me to the university and he has proven the conduct that I was engaging in, right, and he links me to the university, he has established that I have posed, and this is important, I have posed an unreasonable risk. Notice the word unreasonable. Unreasonable risk to his legitimate interest. Right? And unreasonable is the key, because when we say that the risk has to be unreasonable, that preserves some modicum of our freedom. Because I can act in a way that exposes his legitimate interest to lots of risks. But he has to tolerate those types of risks because they don't pose any unreasonable threat, right? So he puts up with conduct doesn't impose that unreasonable risk, right? And what makes it unreasonable is the magnitude of impact that it may have on his operation, the magnitude and the type. Right? Now, notice I said may, and notice I said unreasonable risk, because many people believe that unless the employee's off-duty misconduct has actually impacted the employer's operational or legitimate risk, if it doesn't impact it, then they're good to go. That's not true. He doesn't have to wait until your conduct actually impacts his operations. The key is unreasonable risk. So the fact that it has to be unreasonable helps to preserve some of the freedom that employees would have away from work to do things. And they might impose a risk, but the risk isn't unreasonable. I'll give you another example. There was a lady, and this is a real case. And you probably saw this on CNN. There was a lady and her friend who were visiting Washington, D.C. And they were outside, and there was this monument of a wounded soldier. A wounded soldier. So this lady stood by the wounded soldier and gave the wounded soldier the monument, gave the monument the finger, and then had her friend to take a picture of her doing that. And then she put it on social media. CNN announced this because it was on social media and they showed it, right? And the next day, the employer contacted CNN and told CNN that that lady is no longer employed. Now think about that. Did the employer have a legitimate interest? And what would be the nature of that interest with one of his employees now on social media fingering a monument of a wounded soldier? You say, well, okay, Mr. Employer, how could that hurt you? Well, that's a soldier, and many people are patriotic. And they see her doing that. If they can link her to that company, if there is a good chance that they can do that, then that employer could suffer repercussions to its operation. And I don't know where she was employed in this country, but she was in Washington, D.C. on her own time. All right, so in a case like that, again, the conduct is proven. The harder part for the employer is going to have to show she's in Washington, D.C., fingering a monument of a wounded soldier. How does that impact you? And then he's going to have to talk about patriotism, probably. And if he lives in say a town or a city where there are a lot of veterans or whatever, it is a problem. All right, so you have to link this. The employee has to link the conduct to his business and show that that conduct posed an unreasonable risk to his operational interests. All right, now, that's what I want to say to you about off-duty misconduct. Now, I'm going to talk about remedies toward the end, but I'll say this about proof of off-duty misconduct will get you fired as quickly as on-duty misconduct. There is no doctrine or standard rule in arbitration that says, well, yeah, but I was off duty. Doesn't matter. Right? Once they establish that conduct and link it to their legitimate interests, the penalties may not differ from those of on-duty misconduct up to and including discharge. So we're not free. We're not free. All right, now moving on. I want to talk to you now about the element of intent in misconduct charge. So I'm moving to basically a totally different subject matter, not necessarily, because you can see how off-duty misconduct may be a type of conduct that requires intent. And when I go through this, if that's not clear, it should become clearer as I work my way through this. Okay, now let's talk about the nature of intent. Intent is something that the employer has to prove. If he charges you with a type of misconduct that requires intent, he has to prove the existence of the alleged misconduct, and he has to prove that the employee intended to engage in that conduct, right? Now, if that conduct is on duty, he doesn't have to establish that nexus or link because you're already on duty. If it's off duty, he has to establish that link. But in addition to that link that I mentioned earlier, he would have to establish that the employee's mindset was intentional. Intent is always established through circumstantial evidence, unless someone says, yes, I meant to do it. If you get someone making a statement like that, and it pretty much has to be the person, the employee, did you do it? Yes, I did. If you don't have an explicit statement like that, 9 times out of 10, the proof of a person's mindset or intent is going to be circumstantial. And when I say circumstantial again, I mean they're going to look at your conduct and they're going to have to draw, again, a reasonable inference. And that word reasonable is very important, because it requires the employer to establish that a reasonable person in that employer's place would have drawn that inference or conclusion. So that kind of stopped you from drawing these wild, unsupported inferences or conclusions from anything. For example, that fingerprint that I mentioned that would be on the surface of a desk, the only inference that one could draw from that fingerprint and be reasonable is that I was present. Whatever else you allege that I might have done in this office, that fingerprint is not going to help you to establish it. It establishes one thing. So circumstantial evidence that supports inferences of disputed facts, like whether I was present here or not, so circumstantial evidence that establishes that is only subject to very, very limited conclusions or inferences. You just can't go off the wall and conclude whatever you want because the evidence is circumstantial. And so it would be here with respect to a person's mindset. For example, that lady who was fingering that statue, did she intend to do that? You look at her conduct. There she is, her photo with her finger up. She said, I didn't intend to. I wasn't really aiming that. I wasn't doing that toward the statue. Well, yes. So what were you facing? Were you facing north and the statue to south? Right? Even then, we might be able to infer that it was about the statue because you're facing north. The photographer, the person who took your picture, is facing you, and the statue is directly behind you. So who were you fingering? The photographer? And now if you are standing in front of that statue with your fingers extended like that, we can infer that that particular gesture was aimed at that monument. So that's how you get into a person's mind, because you can't read their mind. You have to look at their conduct and you have to draw reasonable inferences from that conduct, right? Your conclusions, and the question is, so you intended to do this. Now, that's a general approach to intent. Go down a little further. What types of charges might the employer bring that would require intent? there are charges like I have that falsification, misrepresentation, and theft. I just use those three, right? Falsification of your, let's say you falsified a document. If the employer wants to prove that you falsified that document, he has to show that you put information there that is not accurate, that is not true. So he has proven the falsification, right? But he has to eliminate the notion that you might have accidentally did it. You might have accidentally put it there. So he has to prove that your misrepresentation on that document was intentional. The fact that it was accidental or negligent doesn't wash. Now, the nature of your job might push back against what I just said. If you have a really, let's say you're working for some highly sensitive national security or some other operation where you are required, before you put anything on the document, you are required to check it, to double check it, triple check it, whatever. If that's the nature of your job, then there may be room for an employer to go after you with a charge of negligence. But for most of us, when he charges us with falsification of a document, he's got to show that falsification was intended. For example, let's say you have an expense account, and it takes care of your travel. When you're doing business, doing the employer's business, you can travel, whatever. And you come back and you record your expenses, and you record something that was more than you spent. And the employer say, okay, you falsified your expense report. Ladies and gentlemen, you know that'll get you fired. Right? So he said you falsified your expense, and you say, oh my God, I made a mistake. Oh my goodness, I calculated that, I added it in, whatever. He's gonna have to prove, in order to go after you, he's gonna have to prove that falsification was intentional. And you can just let your mind run free. He's got to come up with some justification for his argument. You know, this wasn't an accident. You intended to do this. And the magnitude of the falsity may be a basis for inferring intent. You say, well, you spent $2,000, yes. And you came up with how much? $3,000. And that was accidental? Yeah, well, maybe not. But if it's 2,250, maybe it was accidental. Right? But one way or the other, the employer has to establish that the falsification, and I have here misrepresentation or theft, and this example basically could take in all three of those, that you intended to do it. Now, this is the reason that falsification, misrepresentation, and theft, I use those, is because those all are stigmatizing charges, stigmatizing. So when an employer asserts a charge against an employee and that charge is stigmatizing, in many, not all, but in many instances, intent is inferred. It is not, it is implied. It may not be in the charge, but he said, you falsified that. Can you show I meant to do it? So a union and an arbitrator are perfectly entitled to say, yes, you don't have to prove that. Why? Because it's stigmatizing. And if it's stigmatizing and you fire an employee for that stigmatizing charge, right? That employee is going to have arguably a much harder time getting a job. Misrepresentation, theft, whatever. Nobody is going to want to hire you to be dog catcher. So with that stigmatization like that, a factor, it's proper to have the employer establish that it was intentional. Now, these stigmatizing charges here, the ones I have here, they don't necessarily have in the charge doesn't necessarily have intent built in. In the employer's work rule, right, that prohibits falsification, misrepresentation, that may not have any mention of intent. Doesn't matter. the union has a right to point that out to the arbitrator. And then the arbitrator, to me, certainly has the discretion to accept that suggestion or that motion from the union that, yeah, well, and the employer can say, well, I didn't know that I have to prove intent. Well, you know what? At this point, if you didn't know that, right, then we need to recess, and we need to come back another day when you have added that to your burden of proof, because you need to prove that. Now, those are charges that require. Think about sexual harassment. That is a death knell to the subject of that charge. And that's a death knell, even if the employer doesn't prove it, you basically dead in the water. But if the employer is going to prove sexual harassment, as destructive as it is to the professional life of the subject, it doesn't require intent. So some charges that can be as stigmatizing as sexual harassment doesn't. So you say, well, Professor Brookins, you just said they all. Sexual harassment is a monumental exception. It does not require intent. And I say again, just the charge itself is destructive. If I'm sitting in my office and one of my female students comes in and she has a problem with her grade, and she comes in to talk to me about that problem, and I refuse to change her grade, and she goes to the dean's office and says, Professor Brookins, I wanted to have him reconsider my grade, and he just propositioned me as a quid pro quo for changing the grade. That's what she alleges. I have a problem. The administration may say, okay, they won't call me Professor Brookins. Okay, Bob, we know your reputation, and we're not gonna go forward with this. And I don't know they very much, but it doesn't matter. I am damaged goods, period, for the rest of my professional life. If I then apply to another school to transfer or move to another school, and they find that I was accused of that, ladies and gentlemen, I'm gonna have a hard time. But yet it doesn't require intent. So just, you can keep that in mind. Why it doesn't is just in the nature of the charges. All right, but that is a slippery slope. And probably arbitrators and courts or whatever should reconsider that, but that's the way it is. Now, there are charges that clearly require intent. For example, if the employer puts the term knowingly in there, that an employee knowingly does that, when you put knowingly or some type of term like that, that requires that mindset, then of course you got to prove the mindset. So if you have charges with those terms, with knowingly or purposefully or something like that, you're going to have to establish intent, because it is explicitly required in those types of charges. It is implicitly required in the charges that I just mentioned, and it's not required in some of them that are still stigmatizing. Now, I go to the employer's burden of proof. I've already mentioned that when an employer charges misconduct, he has to establish that misconduct. Now let's talk about the degree to which he has to establish it. He has to establish that type of conduct. So in the arbitral record as a whole, and when I say that arbitral record as a whole, when the employer has presented its case in chief and rested, and the union has presented its case in chief and rested, the employer's charge, considering all of that evidence, the employer's charge has to be there to a point where a person can say, more likely than not, if they can say more likely than not, the grievance of the employee engaged in the misconduct, that is proof by a preponderance of the evidence, and that's all that's usually required. Think about that. More likely than not. What it means is you probably did. That's a pretty low standard, but that's the standard that's used not only in arbitration for the most part, but also in any civil litigation. More likely than not. So you're thinking 51%. The employee's evidence has to reach a point of basically 51% where somebody can say more, and that's a quantification of more likely than not. That's what he has to do. Now, there is one exception to that, and that is that stigmatizing conduct that I mentioned earlier. Unions are entitled to ask the arbitrator that to increase the proof, the quantum of proof, increase that from preponderance to clear and convincing if it's stigmatized. Now, let me give you an example of that. I had an arbitration case some many years ago where a lady was charged with unauthorized replenishment of her leave. Now, this lady, the agency she worked for, her job was to maintain a computer on a computer database, maintain accurate representations of employees' leave. Everybody in that particular company, all employees, her job was to maintain running accurate accounts of how much leave these employees had. She had a cubicle, she had a computer, and she had a password. Now, her sister was diagnosed with terminal breast cancer. So her sister was, put in hospice. And the grievant here, the lady, burned through all of her leave, tending to her sister, caring for her sister. So she had no leave left. Her sister was dying. And in the computer that was on that database, her leave balance was right there with all the other employees, but her leave balance went to zero. And after it went to zero, a few days later, it popped up to about 1/3. Now, management, even though that lady had the exclusive, her responsibility was to maintain that database, management also from time to time would review that database. They reviewed the database, and just because there was a current, there's a display of your current leave, there was also a history that was maintained in the computer, on the computer hard drive. So they knew what it was, and they know what it is now. They looked at it, 3 days, it goes from 0 to 1/3. So they launched an investigation, and this is what they found. They found that when that leave balance was replenished, and they know the minute, the second that it was, because it's computerized. When it was replenished, she was at work. Right? She was at work, and it was replenished on her computer in her cubicle using her password. Now she took a Post-it note, wrote her password on there, which was a long password, wrote it on there and put it on her cubicle wall. So you got the password on her cubicle wall, you got the computer there, and the leave was replenished there in that setting. They noticed she was at work, but they cannot prove that she was at her computer when that leave was replenished. They fired her, and they charged her with unauthorized use, unauthorized replenishment of her leave balance. So notice they didn't charge her with theft. Because if you charge her with theft, you got to prove intent. So they charge her with unauthorized use, unauthorized replenishment of her leave. Now, think about this. The employer has to establish this. Right? He has to prove ultimately by a preponderance of the evidence, more likely than not, that she did this. So the proof he had was that she was there, it was done for her computer, and it was use of her password. And they also pointed out that with her sister dying, she had the motive to engage in that type of action. So the question is, did the employer satisfy the preponderance of the evidence test? Can you say from what he proved that more likely than not, she did it? Now, the union's claim was, look, with that password on her cubicle wall, anybody could have walked in and did it. That was their argument. So you got the employee's evidence, you got the union evidence. That's what I mean by, at the end of the day, you got to look at all of the evidence and decide whether the employer has established their case by preponderance of the evidence. Right. Now think about this, more likely than not is the standard. And then think about, suppose the standard was clear and convincing evidence. Listen to that, clear and convincing. That means that the arbitrator has to be clearly convinced as opposed to more likely than not, right? Moving the standard from preponderance, which is the workhorse in arbitration and civil litigation, moving it from preponderance to clear and convincing can change everything. And as I said before, when it comes to stigmatizing claims, unions can request arbitrators to elevate that standard from preponderance to clear and convincing. But the way I see it, the union ought to ask the arbitrator to do it and not have the arbitrator do it himself. But that can change everything. My decision would have been very different had I applied clear and convincing. So the important thing about this is proof. The employer's duty to prove the existence of most misconduct is the vast majority of it is only going to be preponderance of the evidence. All right. Now, the same thing with the proof of intent. You only got to prove intent by preponderance of the evidence, more likely than not. That's a very low level, but that's the way it is. That's the way it is. Now, from this, I want to move on to the remedies and consideration of remedies. Once an employer establishes the existence of misconduct and proves the elements that he has to prove, nexus and intent, if it's off duty and it requires intent, he then has to decide what penalty to impose. Now, I'm not, in this particular presentation, I'm not discussing necessarily notions of progressive discipline, but that is a consideration here. And if I have time today, I will definitely hit that. But the employer's penalty, just like the rest of his case in arbitration, is subject to review by the arbitrator. Just because you prove that the conduct existed, just because you prove that the conduct was off duty, but it posed an unreasonable risk to your legitimate interest, just because you prove the conduct was intentional, doesn't mean that the penalty that you decided to impose is reasonable. That penalty needs to be reasonable. And reasonable, broadly speaking, reasonable means that the penalty, you heard this before, that the penalty needs to reflect the egregiousness of the conduct. Right? You could say that the penalty should fit the crime, but we're not talking about criminal law. So in this case, that penalty should fit this. So we have quite a few standards, and I've summarized them here. Right? For example, if you haven't notified, if the employer hasn't notified employees of what's expected of them in its rules, then the employer can hit a hurdle there in terms of notice. If you don't have a time period for your employees during which they can take lunch, say, 30 minutes or whatever, you don't have anything posted, right? And the employee takes 35 or 40 minutes. You can say, well, that's too long, and I'm going to discipline you. No, you may discipline him, but most arbitrators are going to reverse it. You need to notify employees of what's expected of them in your rules. Now, your rules, then this is important, your rules need to be reasonable, and they need to be reasonable in terms of they need to be rules that protect your legitimate interests. You don't have a right to enact rules at work that have nothing to do with your operation. So you can't tell somebody, well, you know what? When you go home, I want all my employees to be vegetarians. Well, okay, I guess you could say that, but I'm not going to follow it. Right? In fact, when I leave here, I'm going to McDonald's, and I'm going to be there for a long time. Right? That kind of thing. So an employer's rules have to be reasonable, linked to his operation, and then you've got to make sure you give employees notice of those rules. That's notice. The next step that you could look at is whether you enforce those rules consistently. Consistent enforcement. These considerations don't go to proof of the misconduct. It goes to whether or not the arbitrator is going to adopt your penalty. All right, so we got notification, the seriousness, whether the disciplinary measure fits the seriousness of the proven misconduct. All right, and that's going to be, now the way arbitrators get at that, right? Most of them look at mitigating and aggravating circumstances. Right? So the way it goes is the employer makes the charge. The arbitrator determines whether the employer has established the charge. And then if it's off duty, whether the employer has established a nexus. And if the charge requires intent, whether the employer has established that factor. Then the arbitrator looks at the employer's case and say, okay, the employer has established its charge. Right? Now that you've established a charge, that means that some level of discipline is probably warranted, some level. And you make that clear to the employer, some level, okay. But I'm now going to assess that level of discipline that you did impose and see if that fits the egregiousness of the nature of the misconduct. And I'm going to look at aggravating and mitigating circumstances. And of those, there could be a lot of them, but the major ones are, number one, what kind of employee do we have? Now what you're trying to do on this charge is you're trying to determine, looking at these mitigating and aggravating circumstances, you're trying to determine whether this employee is subject to any kind of effort to change his conduct. Right? See if he can change himself herself going forward. So you look at their disciplinary record. Do they have any active discipline? Active. And this depends upon either the parties' practices or their agreement as to how long discipline can stay in the employee's folder. Right? So if he has discipline in his folder, right, and they've agreed that that discipline can be there 1 year and is still in his folder, then the arbitrator should not recognize that discipline. So for all intents and purposes, even though that old outdated discipline may be still physically present in the folder, the employee had no active discipline. Now, the second one is, say, to look at the employee's tenure. How long you've been there? The longer you've been there, ladies and gentlemen, the longer you've been there, right? To some, and I'm going to say this because this is, to some extent, the longer you've been there, the more secure you are. Now, the reason I say that because I have to preface that, if you engage if the conduct that you engaged in was insubordination or theft or sexual harassment, you could have been there all of your life and still get fired the first time. Some types of misconduct, proof of them, are so destructive to the parties' relationship that arbitrators will basically allow a very senior person to lose their job upon the first act where that's proven. But generally, long tenure can be a mitigating circumstance. Now, if on the other hand, you only got there, you've been there for 10 days, whatever, a month or two, and you commit, you engage in misconduct, you don't, that short tenure becomes an aggravating circumstance. So a short-term employee can get fired for engaging in the same type of conduct that a long-tenured employee would not lose their job. They may have some level of discipline, but not dismissal. So you got discipline, and you've got what you have in discipline and your tenure. The third one, the major one, is job performance. How have you performed your job? If you perform your job and all you need to do is be satisfactory, you don't have to be, superb or excellent and whatever. If you have those types of commendations or that type of recognition, then you're good. That makes it an even more significant mitigating factor. But you only need to just do your job satisfactorily so that job performance will become a mitigating factor and not an aggravating factor. The worse your job performance, the more aggravating. The better, beyond satisfactory, the more mitigating. All right, now, so we go down here. Now, so there's notice. You got to give notice. You got to have consistent enforcement. And the arbitrators are going to look at these areas. They're also going to look at progressive discipline. But progressive discipline is not, it doesn't fall in the category of necessarily whether you consistently did it. Progressive discipline is going to be usually more linked to those mitigating, aggravating circumstances. It's going to be linked to those stronger than it is to other considerations. But a failure to give notice, a failure to consistently enforce your rules, or if you, in the arbitrator's view, did not give the proper weight to job performance and those other mitigating, aggravating circumstances, yes, you proved everything about the employee that in terms of what your charges were, but the chances are the employee is going to come back to work if the case was a dismissal case. If it was a suspension case, then there's a chance that the suspension would be reduced. Now, the other thing, and the last thing I want to say about this, because I'm out of time, but is this: an arbitrator's remedial assessment is basically purely subjective. Now, maybe most arbitrators are not going to admit that. Ladies and gentlemen, it's basically purely subjective. If you're going to reduce, and when I say subjective, this is what I mean. First of all, you got to weigh all these factors, and you are basically second guessing the employer. Now, let me add this, because I didn't say this. An arbitrator should not modify an employer's disciplinary measure unless, looking through all of these here, basically, you can say that it was unreasonable, that the employer's choice of discipline was unreasonable after going through these assessments that I just mentioned. If it's not unreasonable, then you need to leave it be. But can you see that that's subjective? That's very subjective. And then not only is it subjective to determine whether it's reasonable or not, that whole process is subjective, right? It's also subjective to say, now that I found it's unreasonable, I'm going to reduce it. Well, how much are you going to reduce If it's a 30-day suspension, I'm going to reduce it to 10. Based on what? You challenge an arbitrator to objectively defend that decision, and they can't. What makes you pick 10 rather than 9, rather than 11 or 12 days, right? And if it's a dismissal, you say, okay, well, you know, I'm going to bring the person back to work, but I'm going to give them a last chance agreement. Based upon what? My subjective assessment and weighing and balancing these considerations. Thank you.
Thank you, Professor Brookins. That was enlightening and kept my attention throughout the entire, our presentation.
Wow, thank you.
We are at the time for a break. If you want a break, otherwise, if you want to stay on and ask questions for the next 12 minutes now, you can do that as well.
In other words, are there any questions that are going to interrupt your break?
I do have a question, Arbitrator Brookins. In talking about nexus to a job, if somebody is after work on their own time and they send an email to other coworkers and there is a suggestiveness, own personal cell phones, and there might be a suggestiveness of sexual harassment connotation in there, how does that fall back to the employer on determining whether there's a nexus or not?
Is the person at work?
Yes.
The person is at work. All right. If they're at work, it makes it easier for the employer to point out that from a number of positions. First of all, you're working, you should be working, and you shouldn't be sending emails, that are sexually harassing. Second of all, you're probably using the employer's computer. And if you are, now, even if you're using your own phone, right?
Yes, own phone after hours.
Okay, after hours.
Yes, own phone after hours, but it's to another coworker texting.
Okay, after hours, you're off duty, you sent this email to this person. That the employer, that makes it more difficult for the employer to go after you because they got to establish that nexus, right? So how much free speech do you have off duty? Free speech. We're getting cases now, not only in arbitration, but even going to the U.S. Supreme Court on the U.S. Supreme Court on a person's free speech, scope of their free speech off duty. Now in the case that went there, it was a student who said some things that caused the school to act against her. But we're talking employees, right? But I would, just from that perspective, I would say that a person's free speech off work to send sexually harassing statements to their coworkers, are the coworkers off duty? Okay.
Yes, everybody was off duty.
That's the equivalent of seeing your coworker in a mall and sexually harass her, right? There's got to be more than that for the employer to go after the employee and win, because there's no nexus there, right? You're on your time, she's on her time, right? And employers still may try to go after you, but you want to ask the employer, what's your legitimate reason? Well, you sexually harassed Doris. And I did. And when I see her again off duty, I'm probably going to do it again. I don't see how that it impacts you. Now, see, if it goes public, a big key to off-duty misconduct is that the public is going to get wind of this. Now, in your case, Doris could come back to work and tell her coworkers that she was sexually harassed by John. That could enhance the employer's ability to go after John, because his argument would be this. No, my other coworkers, the other workers who now know that you acted like that, may not want to engage you. they may not want to work with you. And if they don't want to work with you, that can impact my legitimate interests. So she could make it public either generally in the neighborhood or whatever, or she could make it public at work. And the nature of sexual harassment is just the allegation itself, as I said, is damaging to you. And it's just as damaging, arguably, to the employer's interest. Right? So in that way, if she publishes that, if she just goes to the employer and says he did this, and she doesn't say anything to anyone else, the employer's case is weak. But if she tells her coworkers, or she makes it known to the public, that employee who did that could have a problem. So you don't have that kind of free speech. And the other thing I wanted to mention that I didn't mention, that I should have mentioned, is this whole thing of social media. This is a mess. And it's a mess that's basically emerging and trying to, the laws, the employees are trying to develop rules and stuff about social media. But what you publish, if you publish your statements or whatever on social media, the question, if you only publish it to people who are, just you got them on your list of friends or whatever, and it leaks to the employer, or it leaks to the public or to coworkers, right? There are cases like that. And the courts are split, and arbitrators are struggling with that. I don't know how the statistics look in arbitral opinions, where you have people being fired for what they said on their public meeting, because they do have free speech, but you don't have free speech that's unlimited. Your free speech is not unlimited vis-a-vis your employer. For example, if you were to go out in public and demean your employer, say things about, even though they may be true, right? Your employer could act against you, and they could act against you successfully. You don't have the right to demean your employer with these kind of public statements. Now, arbitrators are going to be split on that, and courts are split on that. Can you say things? For example, if I'm a professor, can I go to the local newspaper and say, you know what? Indiana University is really, really a very racist institution. I say that to the Indianapolis Star, right? If it's true, they can come after me. And if it's false, they can come after me. And their success may be greater if it's false, but it's not to zero if it's true. You don't have the right to bear your employer's skeletons in your employer's closet to the public willy-nilly. You don't have that right. And that may seem, well, wait a minute, Professor Brookins, if it's true, can I publish it? You do it at your own risk. You do it at your own risk. An employer has a right to protect his legitimate interests, even if he has done something to undermine that interest in-house. He has a certain right. Now, I tell you again, the courts are split and arbitrators split. Now, another thing that comes up with employees and this social interest, employees are asking applicants, job applicants and employees, to give the employer your password to what, Facebook or whatever. They're asking, and in some cases, they're demanding it. Look, ma'am, if you want a job here, yes, ma'am, we need to look at your, because their argument is we have a right to give you a job application, have you fill it out truthfully. And based upon that right, we have a right to know more about you so that we can judge whether we should hire you. And if you're an employee, whether we should retain you. Right? We have a right to know what's going on. That is litigated heavily, and nobody knows where that's going ultimately. But forcing they're saying we can force you to give us your password, just like we can force you to have a physical examination as a precondition to employment and a background check and an application. Those types of searches gives us the general right to know something about our employees who we are hiring. So we can really learn a lot about you from what you're saying on these social media. It's already with us. And you can see, I can't sit here and give you a cut and dried answer as to where arbitrators stand or where courts stand, because they're all over the place. I find that to be a really challenging issue. Now, you can always come down on the side if you want to as an arbitrator, where you can say, you know what, look, this is off duty, and no, you don't have a right to either hack it or to force someone to give it. You don't have that right. It's not that clear, because I have rights, general rights, to know things about you. Right? And now you're drawing why are you drawing that that line at social media? And they say, well, privacy. Look, everything that I force you to tell me also involves privacy. When I do a background check, when I ask for an application, right? Or when I do a medical, all of that is about privacy. So why are you drawing the line here? It is not straightforward. It is not straightforward.
Thank you, Arbitrator Brookins.
Okay. All right. I think they're probably going to take my time. You know, I'm sorry if it does, but you know, I promised. I think Mr. Hoffer that I wasn't going to impinge upon his time. So.
Thank you. This was one of those presentations we probably should have just allotted the full 2 hours.
Okay. Well, ladies and gentlemen, I appreciate your having me today, and thank you. I enjoyed it.
Thank you.
Thank you.
All right. Yes. And I'm going to just kind of get off the screen here and listen to Mr. Hoffer, and because I'm going to learn something. I know I am.
Now, Arbitrator Gary Cloffer, he is also a vice president for Colera. He established his arbitration practice in 2016. He is currently a panelist for the American Arbitration Association and the Federal Mediation and Conciliation Service, FMCS. He's also recently accepted on the National Mediation Board, as well as the Postal Service panels for Mail Handlers Union, AFL-CIO, and the American Postal Workers Union's AFL-CIO. In addition, he is certified as an arbitrator for the states of Oregon, Washington, Montana, Ohio, Kentucky, and Pennsylvania. Prior to his arbitration experience, Gary has served almost 45 years as an elected officer for the American Postal Workers Union at the local, regional, and national level. Gary, I did upload the PowerPoint slide through the chat. Are you able to do it on your own, or do you need assistance?
Well, I never did this through chat, so what do I do?
Oh, no. If you need to go down to share your screen.
Share screen? Okay.
And you want to hit your PowerPoint.
Did share?
Well, you're sharing contract interpretation right there.
Oh, that's the wrong one. And
That's the wrong one.
I'm already off to a great start. Let me see. I think I got the right one this time.
You want to go up to slideshow?
To a slideshow, sure.
And you want to start it from the beginning.
That's where I'm at. This page, that's the first page.
No, up below your file. It says from beginning.
Slideshow. Oh, yeah. What is that? Okay,
And that is you.
okay. All right, just let me know and I can start talking.
I'll just turn this presentation right over to you right now, Gary.
I thought you had him go for lunch.
Pardon me?
I thought you just gave him lunch. Did I misunderstand?
Oh, no. We are starting your presentation now.
Okay, well, I'm going to assume, and I know that's not a very good thing to do, especially in arbitration, if you're an advocate. If you're an arbitrator, I know you're not going to assume anything. But my case is about developing a theory for theory for your case. And that's critical, because to develop, it's a plan. You know more about the case than anybody else if you plan correctly. And you know your weak spots, your strong points, and you also know what the other side's weak spots and strong spots are, and how you will handle those during the hearing. What witnesses to put on, who can testify if it's necessary to bring another witness to the stand. But I don't know how many people are experienced advocates that are out there, but I can tell you that one of the biggest weaknesses of a new advocate is they feel they have to let the arbitrator know everything. So once that happens, as an arbitrator, I know that they don't have a theory, and that's not very good. So as it says on the slide, any controversy for arbitration, any controversy or claim arising out of this contract shall be settled in binding arbitration with its collectively bargained rules. There cannot be a multitude of disparate employee contracts, each having a different normative content. When workers are all performing essentially the same function, all are occupying similar relationships and hence are subject to essentially similar norms. In other words, in the workplace, you may have different jobs, but your collective bargaining agreement is what controls you. If you think you've got so that's what, if you file a grievance, grievance has to fall within the scope of the collective bargaining agreement. You have to claim and identify that. If you're the advocate, that's something you want to make the arbitrator aware of. Just don't hand him the contract, him or her the contract, and say, and then go about your case. So go to the next slide. That's the theory of the presentation. There. Your case theory provides a basis for preparing for the arbitration hearing and presenting the case in arbitration. A properly developed theory directs you to the central issues in dispute. Evidence supporting every element of the legal theory must be persuasively presented. Developing a theory of the case is one of the most important tasks you perform in preparing for an arbitration agreement. The case theory is the strategic plan for achieving your goal in arbitration. Now, I want to back up a little bit because I included in here a legal term that doesn't fall in your presentation, and even if you're an attorney, arbitrator, I'm not an attorney, when arbitrators start talking and I don't understand them, I ask them right away, hey, I just tell them, I don't understand Latin, speak English. Because you want me to rule in your favor. Don't get me lost in the minutia. I said every evidence supporting every element of the legal theory. You should not be making a legal theory. You should be making a theory based upon the contract language itself, because that's the legal theory that's going to get you there. And the preparation begins long before the arbitration hearing. It begins by having an agreement to arbitrate, not simply having an arbitration clause in the contract, but having the other party's signature on the contract or other proofs to show that an agreement to arbitrate exists. Now, I haven't run into this issue, but if you have a collective bargaining agreement, you're going to have language to that effect. And of course, the parties have a signature at the end of the collective bargaining agreement. If you're in a non-union employer, then you have to get the employer to agree to arbitrate. But this is important about the preparation begins long before the arbitration hearing. You have to know every up and down, especially the bad parts about what's the weaknesses in your case. And so you don't want to learn at the table that Joe or Mary did this and nobody told you, because you don't want to be shocked at the table. Now, the theory of arbitration case presentation, you examine your contracts carefully to determine there's a time bar for the submission of a claim or for the initiation of an arbitration. Submit your claim in a timely fashion. Development of a case theory begins after you learn the initial facts through interviews and informal investigations. Throughout the preparation and presentation of the arbitration case, the theory of the case may be revised and updated as more information becomes available. So it's very important when you're an advocate, you're putting on a case, you develop your case and you develop your theory, you know what you want to, you know what you have to prove, and you believe you have all the facts. And the hearing starts, and there's changes to the facts, changes at when you've got to, as they say, be on your toes. You may have to revise your theory rather quickly. And that's why it's so important to understand everything. You want to know everything, good or bad, when you do your preparation for each witness, especially the grievant. If it's bad and it's not going to help the case, you don't have to go there. Let management go there. They may not know about it. Or let the union know about it, because they may not know about it. Or don't let the union know about it. But you don't want the other side to know the weakness of your case at the table. I'm sure they're well prepared, but both sides are normally well prepared, but you don't want to help them out. When an employer or employee violates a section of the collective bargaining agreement, then both parties, if unable to resolve the dispute within the grievance process, only the union may seek arbitration as a dispute resolution process to settle a dispute with little or no disruption to the workplace. Now, the union advocate knows, and most of the time the union knows that they're the only, it's their grievance, it's their property. They're the only ones that can decide whether it goes to the initial step, to the next step, and they're the only one who can take it to arbitration. The employer does not have the ability to force a case to arbitration. They may not agree on anything. They may have denied your grievance at all steps, but eventually the decision to arbitrate belongs to the union, and they will have to decide if that grievance needs to be heard in arbitration. The theory of the case provides a tactical structure for serving as your organized principle for the arbitration hearing. And that's something that's very important. I think some advocates lose the fact that they're, you just can't go to the table. You have to have what's going to be the first part, tactical structure. I don't know how many of you were in the military, but we were taught if we were going to take something, we had to have a tactical plan. We had to have certain things to go forward. The same way with you in preparing and presenting your case. You have to structure your case in a tactical manner. You don't want to put, for example, item D before item A. As an arbitrator, you don't want to confuse them right away. You don't want to confuse them at all, but you don't want to confuse them right from the very beginning. So you should have a tactical process of how you're going to interview witnesses as well as evidence. And a properly developed theory of the case will provide guidance for your presentation. For example, investigating, interviewing, selecting witnesses, preparing an opening statement, selecting exhibits, examining witnesses, and preparing closing arguments. And I think I covered that a little while earlier, but that's what a tactical structure is. All these things that are listed in this paragraph have to be tactical. And if you take them out of line, I know you have to do your opening statements before you put exhibits in. Or you have to do an opening statement before you start examining witnesses. Now, you may need witnesses to introduce exhibits. And of course, you should prepare your closing prior to the case even starts. You should come in with it outlined. There's a lot of advocates that like to have lengthy closing arguments. They, as an arbitrator, a lot of advocates are attorneys, and what attorneys like to do is write. I love written closing arguments as an arbitrator, simply because I have some difficulty keeping up with notes. So when I get this written argument from both sides, it's so much better. But you don't have to have a written closing argument. If you've done everything ahead of that, you did it correctly and in detail, you can verbally close. There's nothing that requires you to submit a written closing argument. You can have a verbal closing argument. It's not going to hurt you and or hurt your party's case. It just means that you have a lot of confidence in your case. All right, if both parties to the arbitration agree on a potential violation of the agreement occurred, then this aspect can be presented as one of the undisputed facts. And usually the advocates will stipulate that occurred. They won't call it an undisputed fact. They'll issue it as a stipulation, and both sides wanted something that neither side will dispute. You want to gather all the documents related to the dispute, collective bargaining agreement, any past practices, written statements, and witnesses, and other supporting evidence and documents supporting their positions. And that's something that you have to do. It's just, you're telling a story when you go to arbitration. You can't skip any pages. You can't go from chapter 1 to chapter 6. You've got to do things. Past practices are important. I don't know if we have a class on past practice later on, but past practices are an extension of the collective bargaining agreement. And if you have a past practice that exists and there's no dispute that it has existed for a long time, that's part of the contract. And they just can't suddenly break a past practice. There's a method of doing it because they're making a change to the contract. But there's a process that they have to go, management would have to go through to break a past practice. But a past practice can be broken, but it has to be broken correctly. But if it's, and for the union, you got a past practice that's been going on for a while, and there's been no problems with it, do not put it in. You risk very, it'd be my recommendations, don't submit a past practice as a contract or as a proposal. Because if you do that, you're telling the employer that whatever that past practice is no longer exists because you want it in the contract. And that's one way that management can break a past practice if you try to put it into the contract. So if you have a past practice and it works, it's part of the contract, there's no need to seek a language in your contract for it. And prepare a brief summary statement setting out all undisputed facts relative to the case. If there is agreement as to what the undisputed facts are, one can avoid discussion at the hearing. Nevertheless, at the hearing, one should have whatever documents that substantiate the facts you present. And those would be your exhibits. You say, for example, time of this incident was 12 o'clock noon, and the other side says, no, it didn't. And you have a picture, and it's bright, sunny day, and they have a picture, and it's completely dark. And 12 o'clock p.m. it shouldn't be, unless there's an eclipse, it shouldn't be dark. So that's what you want. I know that's kind of a radical example, but nonetheless, you want to show, have some exhibits. You can submit it a document, whether man or the other side agrees to it or not, as your exhibit. If they agree to it, then it's a joint exhibit. So you may have, for example, the grievance papers. That's a joint exhibit. And clearly state what facts are in dispute and offer whatever proof you have to substantiate your interpretation of the facts. So that's something you want to tell the arbitrator early on. You're not giving away your case. By the time the case gets to arbitration, the other side knows, should know everything about your case as you do, if they've been doing it correctly. So if you got some proofs and you want to submit them in the opening statement, I think that's a good idea as an arbitrator. I use them to make, because it makes more sense as you put your case on. As you're putting your case on, anticipate what points can be asserted that will seriously weaken your case. One can be caught completely by surprise at an arbitration hearing, because the facts or interpretation are submitted which never surfaced in the discussion that took place between the parties prior to the hearing, or the union or management has not let their advocates know all the facts. So you don't want to put your advocate in that position. Your theory of the case must maximize your opportunity to win. You should try to turn difficult facts to your advantage. You do not want the opposing party to set the agenda or the pace of the hearing. If you know there's something bad that's going to come into the record, tell the arbitrator. The other side is going to put it in. You tell the arbitrator about it. Explain it. Tell the arbitrator what it is and why he or she should not consider it, or not consider it, or give it much weight. So before the hearing, you want to assemble all the papers you will need at the hearing. Make copies for the arbitrator and the other party. All materials should be delivered or mailed to the arbitrator so they are received by the arbitrator. Now, I've never had any exhibits mailed to me. Other arbitrators might, because you've submitted all the exhibits at the table, and sometimes you get stacks of paper, and it's not. And don't be concerned if the arbitrator says, for example, you presented all this paper. If he asks the employer, for example, they just mail it to him. You've already given the same stack of paper to the employer, and all you're doing is, rather than making an arbitrator carry all that stuff with him or her, whether they're driving or going on a plane, for example, then, just offer that. And you should never object to that either, that they're going to send something that's not been presented at the table. The arbitrator is not going to look at that document that has not been presented or testified to at the hearing. Don't worry about that. So if you have witnesses, write down what each witness will prove. This will be useful to you at the hearing to help you make sure that nothing is left out. You may have witnesses present to testify at the arbitration hearing, and you may obtain subpoenas to compel attendance of witnesses and production of documents prior to the hearing. My background is the CBA contains language regarding the trading of documents during the grievance process. And so if you have asked, so you should ask for what you believe is the necessary documents to prove your case, and the other side has said no, you want the arbitrator to know about that. I can issue a subpoena, and if you don't follow it, I have no authority. Unlike on Law and Order, where they can come and have you arrested for not producing something on the subpoena. I can't come to your house or your office and start grabbing stuff. But the point is, at arbitration, when it gets that far, the parties have cooperated and their positions. Both parties know what their positions are, and they have documents that they're going to rely on. Those documents should be shared. You don't want, one thing you don't want to do is try and sandbag the other side. You don't want to hold on to something that's important and wait for the hearing to put it on the table. It's possible that had either side knew about the document, had knowledge of the document, may have resulted in both sides saving a lot of money and not going to arbitration. So I recommend highly you share your evidence, and as a union advocate, this request for evidence should have been made prior to and early on in the grievance process, and not the day before the arbitration. I've said it indirectly several times, but you want to look at the case from the opposing party's perspective while preparing your case. When I was an advocate, I did that. I sat down and went through the case. I prepared management's case in my hotel room or wherever, union office, the day before what I thought was going to be management's case. And based on the documents that were present and statements that they may have written and how they may hurt or help. By doing that, you prepare your case. You're preparing your case as well, because if you recognize that your case has some sort of weakness, then you want to be able to tell the arbitrator plan. We talked a little earlier about a strategic plan. You should know, because what you don't want to do is argue in front of the arbitrator about what was given and what was not given. So provide that information. And it's very important to look at the opposing party's perspective while preparing your case. And there may be strategic reasons for using multiple theories. For example, in a discharge case under the CBA's just cause clause, the union may decide to use as its theory that the discharged employee was not insubordinate. It may desire to use the alternate theory that even if the employee was insubordinate, the disciplinary penalty imposed on the employee was too harsh. And that's going to be a case-by-case basis. The union has records of how the discipline cases have been resolved or issued, and so does management. They should, both sides should. And if the case is bad, if you have a disciplinary process, it goes from, say, a written warning to a 7-day suspension to a 14-day suspension or to a discharge, and management goes right to discharge. And depending on what the charge is, the union would say, hey, wait a second. That it's way too harsh. And the penalty is way too great. So you want to be careful on how you present your case. And that's a very good thing to keep in mind, that the alternate theory is that, well, yes, he did say it, but here's the reason why. And because of the reason why, the discipline is too harsh, too much. your theory should correspond to the common law labor arbitration principles. And if it's your first case, unless you sat in and watched a lot of cases and prepped a lot of cases, you're going to have a hard time understanding the common law of labor arbitration principles. They're not written down anywhere. You'll go to your union, will probably send you to classes where a union officer will teach you how to become an advocate. But
Unknown caller.
the common law and labor arbitrations we've covered it. The common laws, you don't want to surprise the other side. You don't, you want to have your documents in order, present, and for example, if you have 10 exhibits, those 10 exhibits go right in order. It's like you're preparing, you're back in school and you're telling your teachers, this is how you got here. This is how I got to this answer. And you just go like that. After considering all prior arbitration decisions, there may be numerous theories that you may choose. And choosing which theory or theories to use is necessary to assess the strength and weaknesses of each potential theory to consider. In preparing for a case, you need to look to see if there's any prior arbitration decisions for the same charge and what was read by what was the union's position and what was management's position in that case. And maybe that'll change your theory or the way you want to present your theory, especially if with the theory that you've chosen, several arbitrators have already seen it and rejected it. So you want to look in the arbitration history and see how other arbitrators have ruled on the case, on the issue. And the theory of arbitration case presentation is the first one is the practical advantage and disadvantage of each potential theory, including the difficulty of establishing a theory. For example, there may be problems satisfying a legal theory and requiring proof of intent of culpable state of mind. The availability of evidence to support a theory must be considered. For example, a theory cannot be established because of lack of witnesses of documentary evidence. You are not able to have you are not able to or have not proven the facts of your theory. So if you can't come in, for example, and say E equals MC squared, and the arbitrator starts looking at you real funny, you know that you haven't proven your case. And the theory that you've chosen is not the right theory, and you got to be quick on your feet to move away from that theory and go on to the and just move on, pretend it never happened. Affirmative defenses include fraud, self-defense, timeliness of grievance, procedural issues. An affirmative defense can be defined as a new fact or set facts operating to defeat the opposing party's claim, even if the facts supporting the charge are true. So, for example, on the management side, they may be absolutely wrong in what they did. If the grievance is not filed timely, too bad, so sad. The great union's not going to go very far because the grievance is untimely. Procedural issues, that's really up on both sides to make sure that they're you put your case in. And you get your case, there's no, for example, the union doesn't say, this is the first time we've seen this particular document. And the factional theory defines what the facts of the case actually are. The factual theory takes the information accumulated and organizes it into a coherent and logical story supporting your theory. And that's what you have to do. I think we've said that a couple of times. When you're presenting your case, you have your exhibits all lined up. So when you go, they all make sense at the end. Okay, you must take into account the established facts in the case. Avoid contradiction of any disputed fact. The arbitrator will likely find to be true. Select a theory maximizing your likelihood of prevailing. Reject any inconsistent claims or defenses that may be raised by the union or management. Factual theory that should explain what happened and why. And that's why you're at the arbitration table. There's a dispute over what happened. Management has, and the union have a different theory. And that's why they're there. And that's what they're going to tell the arbitrator, why they're there. The theory, let's see. Anticipate the factual theory from both sides. We've covered this a little earlier. You want to prepare both sides, the management or the union's side of the case, before you go to the table. Determine the evidence that is likely to prove and which will not prove its theory. Arbitration hearings are less informal than trials in the court. There are no strict rules about how you must provide information. The arbitrators may choose not to consider information that they believe is not to the point of the case. Facts are convincing if proven by documents and testimony of the relevant union or management official. Just saying something is true means much less. A witness is more convincing when their testimony is not merely restating what a witness might have stated previously, especially when witnesses are not sequestered. No matter how important your facts may seem to you, they must be presented clearly and in a logical order for the arbitrators to understand their importance. And I'm assuming everyone there knows what sequestered means. If you've been in an arbitration, if you bring your witnesses in and they have all their witnesses, you can request the arbitrator to sequester all the witnesses, and they have to leave the room. And the only one that can come in would be the one that's going to testify. Now, the one that you can't make leave will be the technical advisor for your hearing officer or for the presenter, or for the person presenting the case for management, or the person presenting the case for the union. They have, they're entitled to be there and hear everything. Even though they may be a witness, they're entitled to be there. You can't kick them out. But all the other ones, they have to leave. And the reason for that is you don't want them sitting there listening to everything. And so they're called and they summarize in their last witness summarizes everything that's been said. They identify all the weak spots. They then hit on the most important parts of your case. And that's what this sequestration gets to. It also is used when there is, and parties recognize that there is a great dispute. You don't trust the other side. Each party should bring 4 sets of their statement and supporting documents, properly referenced as Exhibit 1, Exhibit 2, etc. These sets are for the arbitrators and for the opposing party. And what is a union exhibit should be marked as Union Exhibit 1. What is a management exhibit should be marked as Management Exhibit 1, and so on. If it's a joint exhibit, it should be listed as a joint exhibit. For example, Joint Exhibit 1, and so on. And that way, during the presentation of the hearing, sometimes exhibits get mixed up. Before you put your next witness on, you want to get those exhibits back in order so that in case they need them. Originals of all documents should be submitted for proper verification and should be marked for return to the parties after the conclusion of the proceedings. I've never had this happen. I don't know what type of document they're talking about, but usually if both sides have been dealing in good faith, whatever exhibit they are submitting is something that the union has not seen. So if there's so if you need something, a proper verification, then a birth certificate possibly, I don't know. Testimony submitted without documentary support may be contested by the other party. A request can be made to the arbitrator to ignore testimony for which proofs are not submitted. That's an important rule. If you got somebody testifying and they don't have any evidence that supports what they're testifying, that's something the arbitrator will pick up on that, but if ever your advocate also should pick up on that. So when they do their closing, that is a target they want to hit. And your opening statement, you should explain the dispute clearly and briefly. This statement will help the arbitrator understand why your facts are important to the dispute. Remember to focus on the case. A logical presentation of your documents and witnesses. You may wish to number each document you plan to present and each witness that will testify. Present your documents and witnesses in order. A statement of what you want out of the arbitration. You have to tell the arbitrator what you want. At the beginning of the arbitration, you ask, it's what shall the remedy be? So that's your statement of what you want out of the arbitration. You may also include the grievance should be returned to work. The suspension should be overturned. He should be paid overtime, whatever the remedy is. But you have to tell the arbitrator what you want. You can't let the arbitrator walk away and he or she's never been told what the union is seeking out of this arbitration. And the closing statement is a summary of your witnesses and documents. You should also respond to the other party's points. And if you have the burden of proof, you've got a little bit of an advantage because you're going last or first on the closing. So you make your closing, and then the other side, it listens to everything you said, and the other side's closing, and you then have heard that, and if there's anything in their closing that you think needs to be addressed in your closing, make note of that as a present their closing, and let the arbitrator know that there's an discrepancy. And there's two sides for each alleged contract violation. And that's why you want to make your side the better document. Okay, that's the end of the slideshow.
Thank you, Gary, for that presentation. Are there any questions for Arbitrator Kleffler? If not, just want to remind you that next week we start opening and closing arguments, statements, as well as direct, I think it's direct and cross-examinations are our topics. I have uploaded the opening and closing statements. Arbitrator Sandra Mendel-Furman would like you to review the fact patterns, write your openings and closings. She'll be calling you next week, to present some, picking from the groups as outlined in her instructions. There's also a coloring page she has included that she wants everybody to color that image and use that as your photo for your Zoom link. And there'll be discussions on that the reasons why she asked you to do that. I want to thank both of our presenters again. Excellent job by both of you. And thank you all for participating. I'll see you next week.
Well, before you sign off, there's a good, it's from Jams, Winning in Arbitration, the 10 Golden Rules. And I don't know the website, but if you write that into your search, Winning in Arbitration, the 10 Golden Rules, it'll bring it up. And it's a 3-page document. And it's a very good document for advocates to read. And I think it's probably a much better presentation than I made, even though that's hard to believe.
Thank you, Gary, for sharing that information.
Can you
Okay.
repeat that again, the name of that again, please?
It's Winning, WINNING, in Arbitration, the 10 Golden Rules.
I just posted the link to it in the chat box, everybody.
Can we leave, is it possible to leave that chat open for a moment? I don't know if it's just mine downloading, but it's taken a moment. I'm afraid.
Actually, you might want to copy it and paste it because we have another meeting we have to get on. Sorry, everyone.
I'll have to remember that excuse.
See you next week.
Thanks, everybody.
Goodbye. Thank you, everybody. I hope it was informative and I hope you learned something.